Any doubts from previous class? No one has any doubts from previous class? All right. What was the topic we was going to? Uniform civil. All of you have gotten the sheet, right? The UCC sheet. Everyone's gotten, right? Just take that sheet out. All right. So UCC is important for next year's mains examination for one simple reason, because Uttarakhand has recently introduced it. So it becomes a static topic also, because it has been previously asked, but it also is important because Uttarakhand has asked this. Which part of the constitution allows for UCC? Uttarakhand has introduced in? No. Under which part. All right, so this is important for prelims also. What has happened is that Article 44 of the DPSP allows for uniform civil code. Uttarakhand has not introduced this under Article 44. What Uttarakhand has did is that you have the concurrent list. In the concurrent list, you have family laws. In this, both the union and the state can make laws. Under the family laws, Uttarakhand has introduced uniform civil code. Okay. So this is one important distinction you also need to remember for prelims. I'll make you write this for mains also, but this is important for prelims itself. All right. Is this part clear to everyone? Yes? Volume. So, volume. So one of the things we're going to start from today is answer writing also. What is going to happen is you have a sheet in front of you, it's a PYQ. I'll make you write the answer. So with the content that we're going to I know a lot of these things you've already learned, but our intent is to make sure that when you write for mains examination, everything that you require for mains, everything that has happened in current affairs, everything that is in relation to static, everything you have written down in notes. So that after prelims, if you qualify, you do not have to make the notes again. You already have every topic, whether current affair or static, pre-prepared. If you know already, you get to revise. If you don't know, then it's good enough that you get to learn something new. But we're going to do both in relation to current affairs and the static part of this. All right. Write down the first introduction to this. Write on in the sheet itself, write down the introduction to in the sheet itself. Right? Write down Uniform Civil Code, Uniform Civil Code, Uniform Civil Code seeks to streamline, Uniform Civil Code seeks to streamline, and what happens is then you write in bullet points 1, 2, 3, 4. First thing it seeks to streamline is laws related to marriage, divorce, adoption, and inheritance. Marriage, divorce, adoption, and inheritance. UCC seeks to streamline laws in relation to marriage, divorce, adoption, and inheritance. That is the core part of what UCC intends to do, is to have a common law on adoption, common law on inheritance, common law on marriage, common law on. What happens today is that you have personal laws. So Hindus have their own personal laws, Muslims have their own personal laws. You have the Ananda Marriage Act for the Sikhs, and similarly for the tribals also, and for the Christians also. The idea is you're going to remove all of this and you're going to have a common uniform civil code. This is something we've talked about when we did secularism also. That in India you have personal laws in the form of minority rights, and we have a principal distance model, and they have a uniform civil code model. If you remember for secularism when we did the comparison. Right on the next part of this. UCC is mentioned in Article 44. UCC is mentioned in Article 44 in brackets DPSP. In brackets DPSP. In brackets DPSP. In the same line, it is UCC can also be implemented. UCC can also be implemented. UCC can also be implemented by both union and states, by both union and states, union and states through family laws, through family laws, through family laws under concurrent list. Family laws under concurrent list. Under concurrent list. Concurrent list. In brackets, recent Uttarakhand law or recent UK law or Uttarakhand law. Recent Uttarakhand law. And right on the last line to this, Goa already has a form of UCC implemented. Goa already has a form of UCC implemented. Goa has a form of UCC implemented. Form of UCC implemented. Now, when Goa became part of India, they were under the control of the Portuguese. The Portuguese had already introduced a uniform civil code in Goa. This part is clear? This becomes your introduction. You have told what UCC is, you have said where it is mentioned in the constitution, and you can make laws on UCC through both DPSP and through family laws, and you have linked it to current affairs also by mentioning Uttarakhand. And you have given the basic example of Goa also. This becomes your core introduction. Can be divided into 2 paragraphs. This part is clear? Then you get to the primary aspect of the question. What is the question asking? What are the problems with UCC? Discuss the factors due to which India is not able to enact UCC. So give a heading. Factors inhibiting UCC. 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 UCC. Again, in bullet points, you write on the first point. The Supreme Court in Jordan case, Jorden, Supreme Court in Jordan case, 1985, in brackets 1985, and you put an arrow next to it. And you just say UCC is a dead letter. 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 So this is what the Supreme Court ended up saying, that even after so many years of independence, a uniform civil code has not been implemented. It remains a dead letter within the Constitution. You get this part? Right on the second one. Article 25, second point, Article 25 guarantees freedom to practice religion. Guarantees freedom to practice religion. Guarantees freedom to practice religion. However, UCC may override. UCC may override personal laws. UCC may override personal laws. UCC may override personal laws. In brackets, you write example polygamy. Brackets, you write example polygamy. So Article 25 talks about the fact that we have freedom to practice religion. Now, the Hindu Code Bill abolished polygamy for all Hindus, even though it was practiced within the religion. But it has been allowed for Muslims. So when you introduce a uniform civil code and you have a common law for marriage, either you're going to allow polygamy for Hindus or you're going to ban it for Muslims. So Uttarakhand, when it has introduced UCC, actually banned polygamy for everyone. So this is one of those problems where this is the main problem, that how do you balance the harmony between fundamental rights and DPSP? in UPSC, you're not going to take that stand because the point is you've already allowed it for Muslims. So you cannot make the argument that it is bad. On a personal level, we may say, fine, it's not something that we look forward to or something that we should have. But you cannot make that argument because as of now, you have allowed it for Muslims. This part is clear to everyone? Right on the third one. May go against popular sentiments. Third point. May go against popular sentiments. May go against popular sentiments. May go against popular sentiments. May go against popular sentiment. Fourth, next point. UCC doesn't capture. UCC doesn't capture. UCC doesn't capture diversity. 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 Full stop. May erase, in the same point, may erase local customs. Erase. ERASE. Erase local customs and lead to alienation. And lead to alienation. And lead to alienation. And lead to alienation. 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 So the idea is that one of the biggest problems with UCC is how do you balance it with India's diversity. When the West introduced a uniform civil code, they were very homogeneous. All of them were Christians. The UCC laws are actually based on Judeo-Christian principles. But in India, you are a diverse country. Every religion and every tribal group have their own ways of marriage, divorce, adoption, and inheritance. So what is going to happen is some local customs would be wiped out. And it may lead to alienation among those communities. It also leads to the next point that there is a fear among minority that if you do introduce UCC, what are the principles going to be based on? It might be based on majoritarian principles. Because that is what happened in Europe also. It was based on the views of the majority. So in India, if you're going to have a common law for marriage and adoption and inheritance and for divorce, it is likely that it may reflect the Hindu codes. You get this conceptually? Right on the next point. It may dilute minority rights. It may dilute minority rights. Minority rights, whereby UCC would impose majoritarian view. UCC may impose majority view. In brackets, like Judeo-Christian principles in West. In brackets, like Judeo, JUDEO, Judeo-Christian values in Judeo-Christian, JUDEO, Judeo-Christian values in West. So what happens is with these point also, you're also introducing a comparative format to it. It's not just about India. You need to bring in certain points where you're actually comparing with others also. This part is clear? Right on the next one. All right. Sure. Right on. Article 371. Article 371. Article 371 provides that Nagas and Misos will have special provision to protect I'll just show you once. Right. So you have this both for the Mizos and the Nagas. That no act of parliament would be imposed in Nagaland and Mizoram in relation to their religious and social practices and customary laws till has been approved by the legislature. So what would happen is, like I'll give you an example. In Nagaland, panchayats do not work. So India has introduced this, the union has introduced this. It would only be implemented in Nagaland when the Nagaland Assembly passes a resolution to introduce this. So what has happened is that by through special provisions, you have given certain rights to Nagas and Mizos. Now, if you're going to introduce a uniform civil code, either these rights have to go away that you have given them for their religious and social practices, or you make it an exception. If you make it an exception, then it's not uniform. This is what has happened in Uttarakhand also. Uttarakhand introduced a UCC but made tribals an exception. Then it's not uniform, no, end of the day. Then every other community is also going to ask for these kind of exceptions, because when you open up the Pandora's box, everyone is going to ask for their own share in this. You get this conceptually? What is the line you have written? For Nagas and Mizos, in relation to their religious and social practices, in relation to religious and social practices and customary laws, and may conflict with UCC, and customary laws and may conflict with UCC, may conflict with UCC, and may conflict with UCC. This point is clear to everyone? Right on the next one. UCC needs to acknowledge LGBT rights in the future. UCC needs to acknowledge LGBT rights in the future. LGBT rights in the future. So if you give, as of now it's not there, but if you give LGBT communities the right to marry each other, that means you then have to talk about divorce also. You also have to talk about inheritance. Adoption, like one of the problems that has happened in the West is that they have introduced marriage and all of these aspects. The problem began when you want to introduce adoption. How would that work in, let's say, if both the parents belong to the same gender? So now they were allowed adoption for LGBT community, but this is the problem in India. If you allow them marriage, you have to allow them divorce. Then you have to also talk about inheritance. Then how would inheritance work in this? Because if one of the spouses dies, then the inheritance should go to the other one. This part is clear? Right on the next one. UCC through Article 44, Article 44 may lead to dominance of center over states. May lead to dominance of center over states. May lead to dominance of center over states. Center over states. Center over states. Center over states. So one of the issue is that if the center does make a uniform civil code, then states have their own. So one of the arguments made by Tamil Nadu is, you allow me to do this under family law. So under family law, Tamil Nadu has made personal laws. Same thing is happening in Uttarakhand. Uttarakhand made it under family laws and not under UCC. So the issue is, if the center is going to create one, this is going to create a particular problem where it would dilute the rights of the state. This part is clear? All right. How many points you have written? 8. Now write a way forward. Way forward. Way forward. Way forward. Write a way forward. Write down Dr. Ambedkar. Dr. Ambedkar has said that UCC, Dr. Ambedkar has said UCC will ensure legal uniformity. UCC will ensure legal uniformity. Legal uniformity. Legal uniformity. Legal uniformity. Next one. The Supreme Court in the Sarla Mudgal case, the Supreme Court in the Sarla Mudgal case, 1995, Sarla Mudgal case 1995, has said that there is no connection, has said there is no connection between personal laws and religion. Connection between personal laws and religion in a civilized society. In a civilized society. In a civilized society. In a civilized. There is no connection between religion and personal laws in a civilized society. In a civilized society. UCC, in the same point, UCC will ensure national integration. Will ensure national integration. Will ensure national integration. National integration. Integration. Next one. It would uphold constitutional morality. It would uphold constitutional morality, in particular, gender justice. In particular, gender justice. In particular, gender justice. In relation to meher, MEHR, meher, stridhan, STREEDHAN, stridhan, inheritance among other, inheritance among other, inheritance among other, inheritance among other, tense among other. So what happens is that currently UCC or personal laws are based on aspects of religion, but a UCC would be based on constitutional morality. It would hold the principles like justice, liberty, equality, fraternity, and dignity of the individuals. So UCC or personal laws may have had triple talaq, but such an action would not be there in UCC. Within Hinduism, you have what is known as Tridhan, meaning the dowry that a woman brings at the time of marriage, it belongs to the woman at the time of divorce. If you look at the Shah Banu case, what was the primary issue? It was over meher. That I think in Islam, when you get married, there is a meher that has to be promised by the husband to the wife if the divorce happens. Now they got married long back, with the amount that might have been promised was very less by the time you get to 1980s. So the Supreme Court said, alimony. Then Rajiv Gandhi got involved, and I don't want to get into the politics part of this. But the idea is a UCC would be based on constitutional morality. This part is clear to everyone? Right on. This becomes a way forward. Then you have to get to a conclusion also. So conclusion can either be a way forward or some summary also. So what are you going to write in the summary? What are the primary keywords? So what are the primary keywords if I were to ask you in relation to problems? If I were to say that you write it in one word, what are the problems? Conflict with 25, 371, and dilutes minority rights and diversity. What else? All right. So what happens is when you are writing in a summary, you pick the keywords and you write the keywords. So what has happened is that you have repeated what you have already mentioned. Now in this particular question, what should be a conclusion? Should it be the keywords of the problem or should it be the keywords of the way forward? Right? Because end of the day, you have to make the mention that UCC is something we have to have. You cannot say that we should not have Uniform Civil Code. Why? Because this has been mentioned in the Constitution. So write a conclusion. Conclusion. Write a conclusion. Supreme Court, write down. Supreme Court in Shah Banu case, Supreme Court in Shah Banu case has said, Supreme Court in Shah Banu case has said the UCC needs to be implemented. The UCC needs to be implemented. UCC needs to be implemented. UCC needs to be implemented. Further, UCC, in brackets, you write DPSP. In brackets, you write DPSP. UCC, in brackets, DPSP, should be seen in harmony, with Article 25, in brackets, fundamental rights. Should be seen in harmony with Article 25, in brackets, fundamental rights. So this is what we talked about in the previous class. The fundamental rights in DPSP should be seen complementary to each other. Right? And write on in the same paragraph. Nevertheless, in the same paragraph, nevertheless, UCC should be implemented. UCC should be implemented with the consent of the people, with the consent of the people, with the consent of the people, consent of the people, consent of the people. So what you have done is neither take a position here or there. You have said, Supreme Court has said it should be implemented. Both UCC and fundamental rights should be seen in harmony with each other. And lastly, implemented with the consent of the people. So this becomes a good conclusion to this. You have not taken a position whether it should be or should not be. You get this? This becomes your answer if you're writing in mains examination. You've highlighted all the facts in relation to UCC. You've highlighted the problems. You've highlighted the way forward and given a conclusion. Every aspect of comparative and of current affairs is included in this. This part is clear to everyone? Was this helpful? So this is something we'll continue in the future classes also. All right, right on the next topic. Next topic. This is right on the next topic. Article 39B, Article 39B, Article 39B, and the Property Owners Association case 2024. Article 39B and the Property Owners Association case 2024. Article 39B and the Property Owners Association case 2024. 2024. All right. So what has happened is that this case was extremely important, came last year, very likely to be asked in both prelims, like what is 39B, but much more importantly to be asked in mains examination. It was not asked this year, but very likely to come up in mains at some point of time. What has happened is that under Article 39B, you have this line that the state shall ensure the ownership and control of the material resources of the community are so distributed as to serve the common good. So this is something we talked about in the previous class. You have concentration of wealth, wealth being land, which was concentrated among the zamindars and the royatwas, and you wanted to redistribute it. So we talked about in the previous class, Article 39B and C would have security over 14 and 19. Now, what the Supreme Court last year has actually defined is what do we mean by material resources of the community? Does it also include private property? Let's say, can the government take away the gold that we have and redistribute it? Yes or no? Like, Indian women are the largest holders of gold in the world. That everyone is aware of. Within that context, this was a fear during the 1970s also. We were going through a financial crisis during after the war itself. And one of the things we did was nationalization. There was a fear that the government may also take away gold. What had happened during the 1970s is when we say material resources of the community, there was a particular famous case that ended up happening in India, which is known as the Ranganathan Reddy case. What had happened is that there was a person in Karnataka who had private buses, used to run private buses. And the Karnataka state government said, no, no. Material resource of the community includes your property. I'm going to nationalize this. They took all the buses of that individual and nationalized it. The idea then it went to the Supreme Court. So I think some of you would already be aware of the Sanjeev Coke manufacturing case. Like you might have heard of it multiple times. In the Sanjeev Coke manufacturing case, the same thing happened. Coke, Sanjeev was a person who used to manufacture Coke, not the Coca-Cola, but it's a byproduct of coal. His company was nationalized by the Indira Gandhi government. The argument is that when you say material resources of the community can be redistributed, does it also include private property? And the argument till 2024 was that it would include private property. And last year they changed the definition. They've given, like in Aligarh Muslim University, they gave conditions. Last year they also gave conditions as to what can be considered as material resource of the community and when can you take it away. The case, the Property Owners Association case, was in relation to that. It's a long back. So during the late 1980s, you had the Maharashtra government ended up introducing a particular law. So what happens is if a building is older than 25 years, it goes for redevelopment. That is quite common, happens in Delhi, Hyderabad, Bangalore, Mumbai, that if the building gets old, goes for redevelopment. The law ended up saying that if 75% of the people within a particular building say yes for redevelopment, the complete building would be taken away for redevelopment. People ended up filing a case that what about the 25%? Let's say if I say no, that I do not want to sell my house, I do not want to send it for redevelopment, can the government take it away by force? They would give me compensation, but can they take it away? That case of 1980s got solved last year. Actually, it's not even solved as of now. They have laid down a test for this. That under what condition this 25% becomes material resources of the community so that it can be redistributed. You get the issue with this? I'll make you write the cases, I'll explain again, but you get the basic crux of this. Write down. Article 39B of DPSP provides, Article 39B of DPSP provides that the state provides that the state shall direct its policy so that the ownership and control of the material resources of the community, are so distributed so as to serve the common good. It's basically the Robin Hood principle. You take away, not from the rich, but you take away private property and redistribute it among the people. The argument has been, what do you mean by private property? And what property of mine, not just land. This Kindle is my property. These videos that the institute has, it is a property of the institute. Can the government take it away and release it on YouTube for free so that it is to serve the common good? Do you get the issue? Right. So they have clarified what do we mean by material resource of community. Write down. Background. Give a heading. Background. BACKGROUND. The Supreme Court in the Ranganatha, Supreme Court in the Ranganatha, R-A-N-G-A, R-A-N-G-A-N-A-T-H-A, R-A-N-G-A-N-A-T-H-A, Ranganatha Reddy case, R-E-D-D-Y, Ranganatha Reddy case, 1977, has said that privately owned resources do not fall under privately owned resources do not fall under the material resources of the community, do not fall under the material resources of the community, material resources of the community, material resources of the community, material resources of the community. However, Justice Krishna Iyer gave a minority opinion. Justice Krishna Iyer gave a minority opinion that both public and private property should be material resource of the community. Public and private property should be material resource of the community. Material resource of the community. The next point. The Supreme Court in the Sanjeev Coke manufacturing case. The Supreme Court in the Sanjeev, S-A-N-J-E-E-V, Sanjeev Coke, C-O-K-E, Sanjeev Coke manufacturing case, 1982, upheld the minority opinion of Justice Iyer. Upheld the minority opinion of Justice Iyer. Upheld the minority opinion of Justice Iyer. Justice Iyer, that it included, that Article 39B included, both public and private resources. Article 39B included both public and private resources. It was again upheld in the Mafatlal case. M-A-F-A-T-L-A-L, Mafatlal case, 1996. M-A-F-A-T-L-A-L. Mafatlal case, 1996. So what happened is, till last year, the view was the material resources of the community would include both public and private resources, and the government can nationalize every private resource, and it would not be a problem. Why? Because 39B is also legal primacy over 14, 19, and earlier 31 also. So they could take away private property and it would not be a problem. And this is what generally happened prior to 1991, that a lot of the industries, banks, you had Canara Bank, private bank, nationalized. You had a lot of coal companies, nationalized. You had buses of Ranganathan Reddy also, later on being nationalized. And this was a problem that happened throughout India. This part is clear? Try down. Current situation. Or current scenario. Property Owners Association case 2024. Current scenario. Property Owners Association case 2024. 2024. So what has happened in the current case is what I ended up explaining. If there is a particular building, it has gone for redevelopment, 25% of the people end up saying no. Can the government take it away? They would give them compensation, but the government, can they forcibly take this away? That case got solved last year. Started in, I think, late 1980s, got solved last year. Write down. The Supreme Court held that not every private resource can be considered, not every private resource can be considered as material resource of the community. Not every private resource can be considered as material resource of the community. Material resource of the community to serve the common good. Material resource of the community to serve the common good. Serve the common good. Serve the common good. The Supreme Court upheld the public trust doctrine. The Supreme Court upheld the public trust doctrine and laid down the following factors to test. 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 Now, when we say public trust doctrine, it is not something new. It was also used in the MC Mehta case also. So in MC Mehta case, it became very popular to be utilized. It comes from a particular Gandhian idea. Which one, if anyone? Trusteeship model. The idea is that when you have material resources of the community, especially natural resources, you might have a private player or even the government in itself that may undertake the exploitation of it or may undertake the work on it. But they have been entrusted for the public good, that it has to be done for the public good and not for private profit. So let's say you take spectrum. Spectrum has been allocated to, let's say, Airtel, it has been allocated to Jio, various other companies like Vodafone and others. It's a public resource which may have been given to private players. It has not been given to make private profit. It has been given for the welfare of the people. You maintain the socialistic idea, which is the welfare state. So these are not being given. Anytime you give coal, anytime you give spectrum, any resource to anyone, including the government or the private player, everything would always be based on public trust doctrine. It is for the welfare of the people and not for private profit. This part is clear to everyone? Write down. Write down the factors in bullet points. Factors in bullet points. First, the inherent characteristic of the resource. 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 Second, its scarcity. Second, its scarcity. SCARCITY. Its scarcity. Third, impact on community well-being. Impact on community well-being. Impact on community well-being. Impact on community well-being. And next, impact due to concentration in private hands. Impact due to concentration in private hands. Impact due to concentration in private hands. In private hands. Impact due to concentration in private hands. So what the Supreme Court has done is laid down these 4 conditions. That based on these 4 conditions, you're going to see whether a particular resource, a private resource, not public. Public, anyways, material resources of the community. A private resource, whether it is a public resource or not. How those characteristics would be implemented, nobody knows. Because the Supreme Court right now has only laid down the guidelines. We don't know of any Supreme Court or High Court judgment where it has been done. So what has happened is that you have these property owners association case. The Supreme Court laid down the 4 guidelines. This case has now gone back to the Bombay High Court. Now the Bombay High Court will look at all of these 4 factors and decide whether those 25% people would keep their house or not. Or can it be or can it be taken away for redevelopment? This is similar to what we talked about the Aligarh Muslim University case. Supreme Court laid down the guidelines, send it to a 3-judge bench to decide on that case. Similarly here, laid down the guidelines, send back to the courts, they'll decide on these factors. You get this conceptually? Any doubts on this? Write down separately. Separately, right? Separately. Certain resources like forest, pond, spectrum, and minerals are material resources of the community, even if privately held. Are material resources of the community, even if privately held. Even if privately held. Even if privately held. Even if privately held. This part is clear? What do we mean by material resources of the community? Any doubts on this part? No one has a doubt on this? Supreme Court has also clarified what do we mean by the word distribute. So write separately. Separately, right? The term distribute in Article 39B, includes both government acquisition, includes both government acquisition and redistribution to private players. Redistribution to private players. As long as it serves the common good. As long as it serves the common good. As long as it serves the common good. Long as it serves the common good. Common good. Right? So when you have these material resources of the community, it can be distributed. Distributed into two ways. The government in itself can acquire and run it. The second way is the government acquires and then redistribute it to private players. So if you see what has happened with what is the slum in Mumbai, which has gone for Dharavi. Dharavi happened before the judgment itself. Now people have ended up saying, they have filed a case against this, that does it meet the determining characteristics of the property owners association case. But the argument is that the government acquired the land and government has given it to a private player. So it doesn't violate technically the property owners association case, as long as it is maintained on the basis of public trust doctrine and not for private profits. This part is clear, right? Any question comes, you write down the current judgment and these are the determining factors. No doubts? All right. Write down separation of power. Separation of power. Separation of power. Separation of power. Vihan Kumar case. Prelims. What has happened, I'll explain to you, but it's not really mains worthy. So in Article 22, it ends up saying protection against arrest and here. A person who is arrested shall be detained in custody without being informed as soon as may be. So the Supreme Court has now defined what do we mean by as soon as may be. They have ended up saying that it should be in a meaningful manner, in a written meaningful manner. What meaningful means, God knows, because we have no idea of this. But what they have said is that it has to be written, which they have said long back also. That you have to, whenever you have arrested somebody, you have to tell him in writing why that person has been put in custody or arrested. And as soon as maybe, they've said it has to be within a meaningful time period. What do we mean by meaningful? It's not clarified. That is the view of the Vihan Kumar case. So I don't think it's going to be asked in mains. Something in prelims, but that's also a little far-fetched. Any doubts? All right. Write down separation of power. Separation of power. Separation of power. Write down introduction. 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 Separation of power is an integral component. Separation of power is an integral component. Is an integral component of modern constitutionalism. Integral component of modern constitutionalism. Of modern constitutionalism. Modern constitutionalism. It has been given. Which thinker? Montesquieu. It has been given by Montesquieu. 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 It has been given by Montesquieu. The doctrine of separation of power implies, doctrine of separation of power implies, doctrine of separation of power implies, write down bullet points. Write down bullet points. Same person, first point, same person should not hold more than one organ of the government. Same person should not hold more than one organ of the government. One organ of the government. So you have judiciary, executive, and legislature. So you should not have one person that is the head of both of them. That cannot be the case. There would be different persons that would end up heading all of this. So you have the president, who's the head of the union executive. You have the CGI, and who's the head of the legislature? Do we have a head of a legislation? No. So as far as the legislature is concerned, it does not have a head. So the idea is that there should not be a single individual that ends up heading any two organs together. The example here would also be seen when we did discuss secularism. Like in Tibet, the Dalai Lama was both the head of the spiritual head, and he was also the political head. If you look at North Korea, the same argument is made there. If one person holds all of these offices, you're going to have dictatorships. This part is clear? Second, there should be differentiation of functions between the organs. There should be differentiation of functions of the organs. Differentiation of functions of the organs from each other. Differentiation of functions of the organs from each other. And third, there should be safeguards. There should be safeguards to prevent encroachment. There should be safeguards to prevent encroachment. Safeguards to prevent encroachment from one organ to the other. Encroachment from one organ to the other. From one organ to the other. One organ to the other. So meaning when we say judicial overreach, what is judicial overreach? It is an encroachment of the judiciary into the fields of legislature or executive. So when you have strict separation of power, these aspects should not happen. You get, this is supposed to be written in introduction, and you write down the last line separately. Elements, which is judiciary, executive, and legislature. Elements, judiciary, executive, and legislature. judiciary, executive, and legislature. So that is how generally modern constitutionalism is divided, that you have these three separate organs. This part is clear to everyone? All right. Write down separately aspects of separation of power. 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 Separation of power. Write down the American Constitution. The American Constitution. The American Constitution envisions. The American Constitution envisions a strict separation of power. Envisions a strict separation of power. Strict separation of power. However, in the same line, however, the Supreme Court in the Indira Nehru Gandhi case, however, the Supreme Court in the Indira Nehru Gandhi case, 1975, Indira Nehru Gandhi case, this case is the same as Raj Narayan case. It's Indira Nehru Gandhi versus Raj Narayan case, which is sometimes also popularly known as election case. So any of the three names would be fine. You can call it Indira Nehru Gandhi case or Raj Narayan case or election case. Indira Nehru Gandhi case, 1975, that the Indian Constitution does not recognize absolute rigidity, in separation of power. Separately, the Supreme Court in the Ramkrishna Dalmia case. The Supreme Court in the Ramkrishna Dalmia, Dalmia, Supreme Court in the Ramkrishna Dalmia case, 1958, has said that the Constitution implicitly provides for separation of power. The Constitution implicitly provides for separation of power. Implicitly provides for separation of power. Separation of power. However, India rather has separation of functions. However, India rather has separation of functions with checks and balances. Separation of functions with checks and balances rather than strict separation of power. Checks and balances rather than strict separation of power. Strict separation of power. Strict separation of power. Strict separation of power. Now, in the US Constitution, it explicitly mentions that there would be differentiation, that there would be a differentiation between executive, judiciary, and legislature. In the Indian Constitution, it's not explicitly mentioned. It's nowhere except you find it in DPSP, separation between judiciary and executive. But there is no explicit mention anywhere that these are three separate organs. So what the Supreme Court in the Ramkrishna Dalmia case ended up saying is that we do not have strict separation of power like the United States. What we generally have is not separation of power, but separation of functions. And this is a very important line to write within the UPSC examination. This separation of function is therefore an aspect of check and balances. You get this conceptually? This has been asked as a question in the past. One of the things is when we discuss PYQs, you'll realize that sometimes the UPSC, sure isn't. Do you think that the Constitution of India does not accept strict separation of power? Rather, it is the principle of checks and balances. This answer really is not complete if you do not mention Ramkrishna Dalmia case, because that is why very important, because it is the case that basically established no strict separation of power, but separation of functions. Separation of functions with checks and balances. This is not the only time. When we do Article 368, there is a particular question that I'll show you, and we'll discuss it. Let me just show you. Like this was asked in relation to basic structure. We'll get to Article 368 basic structure. We'll ask Parliament's power to amend the Constitution is a limited power and cannot be enlarged into absolute power. Which judgment said this? It's not Kishan. Minerva Mills. The point is, if you do not write the judgment, which judgment said this, you may get marks, but somebody who ended up writing would get better marks. This is something we discussed in the 2024 questions also. If you remember that question we discussed on constitutional morality. Where is it? The constitutional morality is the fulcrum which acts as a check on high functioning citizens' life. I told you which case they have borrowed it from. NCT of Delhi case 2018. So what the UPSC has now done is that every 1 or 2 years you get a particular statement where they have taken a particular statement from a case law. And they have mentioned it in double quotes within the question. And now you have to mention where they have taken it from. If you don't know, it's not a problem. But somebody who mentions would get much better marks as compared to those that do not. And these lines that they end up saying, these are not like randomly picked from any case law. It is the case law that establishes that particular aspect. Ramkishan Dalmia case establishes separation of power on how it is seen in India because it is one of the first cases of 1958. You get this conceptually? Right? Write down. The Supreme Court in the Keshwananda Bharti case, the Supreme Court in the Keshwananda Bharti case has said that separation of power between executive, judiciary, and legislature, the separation of power between judiciary, executive, and legislature is basic structure of the Constitution. Basic structure of the Constitution. Basic structure of the Constitution. And write down the last aspect. Article 50 in brackets DPSP. Article 50 in brackets DPSP provides separation of judiciary from executive. Provides separation of judiciary from executive in the public services of the state. Public services of the state. Can you give me an example where they have done this? Made the separation between executive and judiciary in public services. How CRPC? District magistrate and judicial magistrate. So what happens is when you look at Article 22 ends up saying that you have to be shown in front of a magistrate within 24 hours. The argument was, what do we mean by magistrate? So during the British time and up till late 1950s, it was the IAS officer that you had to be shown in front of the IAS officer. Then you made a distinction that no, it's going to be judicial magistrate. That's why there is always a confusion. District magistrate and judicial magistrate. So write down the example. Separation of Executive and Judicial Functions Act. Separation of Executive and Judicial Functions Act in several states and union territories. Several states and union territories. So what has happened is that it must be let's say, it's not coming up. So everything is just UPSC. Anyways, if you were to search it for online, you would find it that every state and union territory, let's say it would be known as the Delhi Separation of Judicial and Executive Functions Act, 1950 something. Similarly, every state would have this. What it basically differentiates is between the district magistrate and the judicial magistrate. This part is clear. So you write that as the example. Try down. Give a heading, overlapping functions. Overlapping functions. Give a heading, overlapping functions. Overlapping functions. Overlapping functions. Overlapping functions. So because in India you don't have a strict separation, what you have is therefore overlapping functions between the judiciary, executive, and legislature. So what you do is draw a diagram like this. In your UPSC examination, just draw it like this. That would be enough. But you give examples next to it where there is a overlapping function, where you have both the organs undertaking the same function. Example? What is it known as in one line? That is an example, judicial legislation. So write on the first example, judicial legislation. Judicial legislation, meaning where the judiciary makes laws. Judicial legislation, in brackets, example, Vishaka guidelines. Judicial legislation, in brackets, example being Vishaka guidelines. Meaning when the judiciary ends up making rules, who makes rules? Legislature. When they make rules or laws, it is known as judicial legislation. It's a separate topic that we'll cover when we get to judiciary. What else is an overlapping function? Judiciary ends up making end of the day, and it ends up saying with the consent of the president. Ordinance. All right, write down. Legislative power of the president and governor. Legislative power of the president and governor. Legislative powers of the president and governor. In brackets, ordinances. In brackets, ordinances. In brackets, ordinances. Write on the third one. Quasi-judicial functions of legislature. Third one, quasi-judicial functions of legislature. Quasi-judicial functions of legislature. What are they? And not privilege. Judges also. Impeachment of president and judges. It's a quasi-judicial function. Impeachment of president and judges. Parliamentaries also deciding. That can also be there. Speakers also deciding on disqualification. That is also there. Okay. I'm just making you write few examples. There are multiple of them. I'm just making you write few examples here. Write down the next one. Double membership. Double membership. Double membership. Double membership. Ministers and members. Meaning the same person is the minister also in the executive and also a member of parliament. Ministers and members. Ministers and members. Ministers and members. So what you have done is given examples for each of them, where these two end up sharing, where these two end up sharing, and these two also end up sharing. So that would be enough. The only thing is you need to give examples, and that's about it. This part is clear? Write down separately. Give a heading, checks and balances. Checks and balances. Checks and balances. Checks and balances. Who said? That no. Checks and balances. I'm going to make you right now. Give a heading, checks and balances. Now in India, we have two different types of separation of power. You have horizontal separation of power and you have vertical separation of power. Horizontal separation of power is directly judiciary, executive, and legislature. Where there is a check by the judiciary on the executive, there is a check by the other two on the judiciary. Similarly, you have vertical. Vertical means the check by the Supreme Court over its own organ. Supreme Court over the high courts, plus tribunals, district courts. The separation of power between the president and the prime minister. The separation of power between the governor and the chief minister. So vertical is within the same organ. Horizontal is between organs. So write down first. Vertical separation, vertical separation maintains separation of power, separation of power between different functionaries, between different functionaries in the same organ, in the same organ, in the same organ, in the same organ, same organ, same organ. What would you write as an example for this? Ethics committee, so parliamentary systems, or parliamentary committees, sorry. Parliamentary committees also do it for the executive. Like parliamentary committees also do it for their own members, like you have privilege committees, you have ethics committee, and parliamentary committees also do it for executive. Right? So you can write the example in both the places. You can write parliamentary committees in brackets, privilege and ethics. Parliamentary committees, privilege and ethics. Privilege and ethics as examples. Parliamentary committees, privilege and ethics as example. What is? I can make you write, but some examples have to come from you also. You're talking about 76, that the president can ask for certain questions, but that's not really a separation of power. Acha, reconsideration of bills. Okay. Question hour, but something a little bit more direct. There's something you can write in one line, easier to do. Write down first. No confidence motion. Oh, sorry, not no confidence. Appellate jurisdiction. Appellate jurisdiction. Appellate jurisdiction. Appellate jurisdiction. So both the High Court and Supreme Court have appellate jurisdiction mentioned in the Constitution, whereby the High Court judgments can be appealed in the Supreme Court and District Court judgments can be appealed in the High Courts. So that is much more in horizontal. So there is an error of law that has been made by the judiciary, the executive gets to correct it. So that is horizontal, not vertical. It's the separation of power or check and balance. Let's say the judiciary has given a particular judgment. There might be an error of law. To correct that, the president has been given pardoning power. So what happens? It is vertical, whereby it is the check and balance on the judiciary by the executive. Vertical नहीं है ना, इसमें president, prime minister उनका कहाँ से दिखेगा? There's no separation. It's one line. I get what you're trying to say. Then, all right, then we can say that in relation to death penalty, the president has one particular aspect as compared to the governor. But you would have to make it a very long line then, because you would have to give the differentiation accordingly. Something in one line. You can write aid and advice. Aid and advice. Whereby the president works on the aid and advice of Council of Minister, and similarly, governor works on the aid and advice of Chief Minister and the Council of Minister. Aid and advice. aid and advice. Or even if you see here, if you look at one of the primary ways where you have this separation of power or vertical separation of power is when you have this line. The executive power of the union shall be vested with the president. It ends up here that nothing in this article shall be deemed to transfer to the president any functions that has been given to any other authority. What it basically, it's the core aspect that prevents India from becoming a dictatorship. It is what prevents or allows for vertical separation of power. What happens is, what this line means is that the prime minister has been given certain powers. Ministers have been given certain power. You as an IAS officer have been given certain powers. Let's say an IPS officer, let's say, has the power to arrest. Can the president say, no, no, I am the head of the union executive. Therefore, all the power that you have is derived from me, so I'm going to arrest. Can the president arrest somebody? Why not? If he's the head of the union executive, why can't he? Let's say you leave that part. He has been given the aid and advice, then why can't he arrest? This is what prevents that from happening. This line ends up saying that nothing in this, even if you're the head of the union executive, nothing in this article can be transferred to any function can be transferred to the president that has been given to somebody else. So let's say there is a particular law that ends up giving powers to the IAS officer, ends up giving powers to the IPS, ends up giving powers to the minister. Even though that the president is the head of the union executive, he cannot take any power that has been given by law to any other authority. This prevents the president from usurping powers of the executive itself, those that are below in hierarchy. This is what allows for vertical separation of power. If this did not exist, then you would have a form of dictatorship. You get this conceptually? So you write down. Write down. Limitations upon the president and governor. Limitation upon the president and governor. Executive power. President and governor, executive power. If you want to write, you can write in brackets Article 53. This part is clear to everyone? There might be other examples also. You can write others also. I'm just making you write few so that you know when to write in the exam itself. That also is there. That when we talk about Article 352, when you want to declare national emergency, then it has to be sent in a written form where all the signatures of the cabinet ministers have to be there. It cannot just be the prime minister. Every cabinet minister has to sign it. So when we get to 352, I'll explain this. But the problem is nothing too long. When you're writing examples, you should be able to write on 1 or 3 words itself. Nothing too long. Parliamentary? So parliamentary committees are also, the Privilege and Ethics Committee is consisting of members of parliament, where they're looking at cases of members where they have breached the privilege of the parliament, or they have gone beyond that. So when we talk about that Mawa Mutra's case, went to the ethics committee. So it is a vertical separation of power where the members of parliament are holding a member of parliament accountable. Okay. All right. Right on the next. Horizontal separation of power. Horizontal separation of power is between the separate organs. Horizontal separation of power is between the separate organs. Write down examples. No confidence motion, where the legislature or Lok Sabha holds the executive accountable. No confidence motion. Impeachment of judges. impeachment of judges and president, impeachment of judges and president, impeachment of judges and president, impeachment of judges and president. Article 13. So the judiciary can declare a law to be null and void. So judicial accountability of legislature. Article 13. Next, courts cannot inquire into advice. Courts cannot inquire into advice tendered. Courts cannot inquire into advice tendered. So whatever the Council of Ministers has given the advice to the president or the governor, the courts cannot inquire into that advice. Next, Parliament and state legislature. Next one. Parliament and state legislature cannot discuss conduct of judges. Parliament and state legislature cannot discuss conduct of judges. Conduct of judges. Conduct of judges. Conduct of judges. Right. So these are few examples. There are a lot of them, but I'm not going to make you write each one of them. In your UPSC answer, you just need to write at least 4 or 5 examples, and that would be enough. This part is clear? That becomes way too complicated with the collegium system. You can, a lot of them. Pardoning power is also there. You can write it here also. That if the judiciary has made an error of law, then the president can rectify those error through the pardoning power. So that is also something you can write here. Say it again. CAG, but that's a separate constitutional body altogether. Right? Because it does not fit into directly between judiciary, legislature, and executive. You get the gist of this? You just write 4 or 5 examples, it would be enough. They can actually discuss only under one conditions, when the impeachment of the judge is being happening. It is a separate, like, there is no interference of the legislature into the working of the judges or of the judiciary. So it is a separation of power, but it is also a form of balancing, where the judiciary's independence is protected from the legislature. Not everything is a check. Some things would be a balance also. Right? This part is clear to everyone? All right, write down advantages. Advantages of separation of power. 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 Write down first. Checks arbitrariness of action. Checks arbitrariness of action. Checks arbitrariness of action. Checks arbitrariness of action. Second, minimizes abuse of power. Minimizes abuse of power. Minimizes abuse of power. Minimizes abuse of power. Abuse of power. So one example that you can write here is Raj Narayan case, 1975. Raj Narayan case, 1975. 1975. An article, just Raj Narayan case itself would be fine. You can also write Keshananda Bharati, Minerva Mills, others also, it's not a problem. But Raj Narayan case was very symptomatic of the idea that Indira Gandhi's election was cancelled. And then she ended up trying to introduce Article 329A. Everyone is aware of 329A? I'll just show you once. What had happened, the government ended up introducing 329A. And basically, it ended up saying that the election of the Prime Minister and the Speaker of the Lok Sabha would be outside judicial review. So what had happened in the Raj Narayan case, Indira Gandhi's election was cancelled. She ended up amending the constitution and said my election and that of the Speaker of the Lok Sabha beyond judicial review. Then the Supreme Court in the Raj Narayan case declared this to be null and void. Why? Because judicial review is basic structure. This part is clear to everyone? Right on the third one. Prevents concentration of power. Prevents concentration of power. Prevents concentration of power. Prevents concentration of power. You can give the example of basic structure. Basic structure and Minerva Mills. Minerva Mills ended up saying that Article 368 is a limited amending power. You can say basic structure and Minerva Mills case 1980. Minerva Mills case 1980. Article 368 limited power. Article 368 limited power. Article 368 limited power. Next one. Reduces chances of dictatorship and authoritarianism. Reduces chances of dictatorship and authoritarianism. Chances of dictatorship and authoritarianism. Next, judicial review to protect individual liberties. Next, judicial review to protect individual liberties. To protect individual liberties. Next, ensures accountability. Ensures accountability. You can give the example, no confidence motion, parliamentary committees here. Ensures accountability. You can give the example of no confidence motion, parliamentary committees. Next, promotes specialization and efficiency. Next one, promotes specialization and efficiency. Promotes specialization and efficiency. Next, encourages stability and harmony in governance. Encourages stability and harmony in governance. Right on the last one. Builds public trust. Builds public trust. Right. Builds public trust. This part is clear to everyone? You understand the advantages? Make sure that wherever possible, just give recent, or wherever possible, just give examples. That would be enough. And just write down a small conclusion. Just one line that is linking it back to current affairs. Write down the Supreme Court in the Nandini Sundar case. The Supreme Court in the Nandini, N-A-N-D-I-N-I, Nandini Sundar, S-U-N-D-A-R, Nandini Sundar case 2025 has said the separation of power must always be acknowledged in constitutional democracy. Acknowledged in constitutional democracy. Constitutional democracy. This part is clear to everyone? Any doubts? No doubts? All right. Right on the next topic. Fundamental duties. Just before writing fundamental duties, just write a question. You write the answer and show to me um, whenever we have the next class. This question that was asked in 2019. Do you think that the Constitution of India does not accept principle of strict separation of power? Rather, it is based on the principle of checks and balances. Explain 2019. 2019. Um, 250 words. 250. Or write 150 words. I want to see it in a much more shorter format. 150 words. 150 words. 150 words. These are the only two questions that have been asked on DPSP. There has been 0 questions directly on DPSP. They have asked on certain topics that have come up in DPSP that are related to polity. One they have asked on UCC, another one they have asked on separation of power. One more they have asked on NALSA also in relation to free legal aid. But these are the only, so no direct question on DPSP till date has been asked. Any doubts? All right. Write down fundamental duties. Write the introduction. Intro. Which one? Tell me the topic. Judicial legislation is not. Judicial legislation comes with 143, 142. That it's in relation to judicial legislation, right? So that question will do when we do judicial legislation. What they're talking about is that you have the judgments of the Supreme Court, they're considered law under the Constitution. Now, when you have made things like Vishaka guidelines, collegium system, basic structure, these are not mentioned in the Constitution. So who has given them the power to make laws? And this is what it talks about, is when you are undertaking judicial legislation, are you breaking separation of power? Why? Because this is a case of judicial overreach. So what is going to happen is first you need to know judicial legislation. So when we do judicial legislation, then we'll talk about this question, and with that, we'll talk about separation of power, where the linkages can be made. Right? Any other doubts? No. All right. Write down fundamental duties, fundamental duties, fundamental duties, fundamental duties were inserted, fundamental duties were inserted by the 42nd Constitutional Amendment Act, by the 42nd Constitutional Amendment Act 1976. 42nd Constitutional Amendment Act 1976 as Part 4A. As Part 4A. As Part 4A of the Constitution. Part 4A of the Constitution. 4A of the Constitution. Constitution. Which committee recommended? It was based on the recommendation. It was based on the recommendation of the Sardar Swaran Singh Committee. It was based on the recommendation of the Sardar Swaran Singh Committee. Sardar Swaran Singh Committee. Sardar Swaran Singh Committee. Were borrowed from USSR. It has been borrowed from USSR, Soviet Union. It has been borrowed from USSR, Soviet Union. Soviet Union. Soviet Union. Soviet Union. Write down the next para. Most of the liberal democracies, most of the liberal democracies, most of the liberal democracies do not have duties, do not have duties and only rights, do not have duties and only rights, do not have duties and only rights, except the Japanese constitution, except the Japanese constitution, except the Japanese constitution, except the Japanese constitution. So there's one small comparative that you end up writing. Most of the liberal US, France, none of the countries have fundamental duties. The only liberal democracy that has a concept of duties is Japan. What about it? See what happens with Universal Declaration of Human Rights. Actually, there was a question asked to Mahatma Gandhi when Universal Declaration of Human Rights was being formed. Mahatma Gandhi was asked for his opinion. He said there should not be any UN Charter of Rights. There should be only a UN Charter of Duties. The argument has been, and it's the core argument with the Supreme Court also, it's a PYQ also, that India and most of the Asian societies, those are not rights-based society, who have generally been duty-based society. So if you look at Arthashastra, you look at Manusmriti, it talks about the duties of the king, duties of the citizen, duties of the Mahamantri, duties of the soldier. It does not talk about the rights of the people. So Asian societies have generally been duty-based society. If a king fulfills his duty to provide protection, automatically the citizens would get the rights of protection. So the argument has been, that was said by Mahatma Gandhi, is that the fulfillment of duties complementarily provides the rights to others. So if I do my duty, if an IAS officer does his duty, IPS officer does his duty, automatically the people would have freedom of speech, freedom of movement, security. That's the core argument. So it's the performance of duties that actually provides rights. So that was the original view with this. But anyways, that is, the original constitution did not contain duties. It only ended up containing rights. This part is clear to everyone? All right, write down. Fundamental duties do not extend to aliens. Fundamental duties do not extend to aliens and is subject to only citizens. And is subject to only citizens. And is subject to only citizens. It is subject to only citizens. 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 Further, fundamental duties are non-justiciable. Further, fundamental duties are non-justiciable and non-enforceable. Further, fundamental duties are non-justiciable and non-enforceable. And non-enforceable. And non-enforceable. Nevertheless, the J.S. Verma Committee, 1999, has highlighted that the fundamental duties have been enforced through suitable legislative laws. Enforced through suitable legislative laws. Suitable legislative laws. Suitable legislative laws. Write down examples. Examples. So, write 51A clause A. 51A clause A. Write down few examples. 51A clause A. Right? So 51A capital clause A. So what is a legislative law or executive order that allows for, how is that had been made enforceable through which law? To abide by the national constitution, flag and all of this. All right, write down. Prevention of Insults to National Honors Act 1971. Prevention of Insults to National Honors Act 1971. Prevention of Insults to National Honors Act 1971. 1971. Comma, National Flag Code, National Anthem Code. national flag code, national anthem code, flag code, national anthem code, national flag code, national anthem code. So this has been made enforceable through these legislative law. What about clause B? To cherish and follow the noble ideas which inspire our national struggle for freedom. How do we make sure that the people fulfill this duty of theirs? All right, national holidays, in the sense Republic Day, Independence Day, Gandhi Jayanti, war memorials. NCRT textbooks. All right, write down the example. 51A, clause B. 51A, clause B. 51A, clause B. National holidays, national holidays, national holidays. NCRT textbooks, NCRT textbooks. National holidays, NCRT textbooks. Oh, it becomes too. Somebody filed a petition that you should do this in the courts also. That before the High Court and Supreme Court, whenever it convenes, you should play the national anthem there also. They said no. God knows. They said before playing films, it has to be done, but before themselves, it doesn't require it to be. But write on the next one. What would you say for uphold and protect the sovereignty, unity, integrity of India? Which legislative laws? You can. But what are the laws that ensures the sovereignty, unity, integrity of India? UAPA, Armed Forces Special Powers Act, Bharat Nyaya Samhita. So write down Article 51A C, 51A C, 51A C, 51A C, UAPA, Unlawful Activities Prevention Act, UAPA, UAPA, AFSPA, Armed Forces Special Powers Act, AFSPA, Armed Forces Special Powers Act, Bharat Nyaya Samhita, BNS, Bharat Nyaya Samhita, BNS, National Security Act, National Security Act, National Security Act. Rest I'm not going to make you write. We'll just discuss. But I'm not going to make you write. To defend the country and render national service when called upon to do so. Territorial Army, NCC. Is there a fundamental right to this also? 20? Yes. It's the first time I've seen somebody actually mention the exact clause also. Right. So what happens in Article 23 talks about prohibition of trafficking in human beings and forced labor. Clause 2 ends up saying that the state can impose compulsory service for public purposes, but would not discriminate on the grounds of religion, race, caste, and all of this. What it means is that the government, if it is imposing public services or compulsory services, you cannot say that the government is making me do forced labor. The core argument is this, that if they are making you do public compulsory services, you cannot say that they're making you do forced labor. You get this conceptually? What about to promote harmony and spirit of common brotherhood? How? Something that ensures fraternity in India. How would you provide that as the example? You can make the argument other way. If somebody harms fraternity or harmony, they can be penalized. So under the Representation of People's Act, if somebody harms the communal harmony, they can be barred from contesting elections. So you can make the other way around argument also, that wherever somebody tries to overcome all of this, or they harm common brotherhood, they can be penalized. What about to value and preserve the rich heritage of our composite culture? Ancient Monuments Act, Archaeological Survey of India, all of these provide for this. To protect and improve natural environment, including forests, lakes, rivers, wildlife. Wildlife Protection Act, this. To develop scientific temper, humanism, and spirit of inquiry and reform. What would you give as an example here? National? What is it for? Achha, you can make the argument. You have this Atal Tinkering Labs also that have been formed. You also have the Maharashtra, I think about 2-3 years ago, they actually introduced a Black Magic Act, meaning prohibition of black magic. So that is also to ensure scientific temper. You also have scholarships, national awards, where people have contributed in relation to science and other aspects. To safeguard public property and observe violence, you have Bharat Nyaya Samhita, you can write here. Strive for excellence in all spheres, national awards, Arjuna Award, Bharat Ratna, Padma Shri, Padma Vibhushan. And this is something that has not been done in India. So it is a fundamental duty of a parent or a guardian to send their child between the age of 6 to 14 to school. But if somebody does not fulfill their duty, nothing happens to them. In the US, you have something which is known as truancy laws. Truancy. So you had Kamala Harris, no? She actually imposed it a lot. Truancy law in the United States says if a parent does not send their child to school without permission, or they would be put to jail, or they would be fined. So in the US, these are known as truancy law. Truancy meaning absentees without permission. So in the US, somebody could be sent to jail, or the parents would be sent to jail if the child does not attend school. But in India, we don't impose for this. So there is no law, legislative law, that provides for this. This part is clear? In your UPSC answer, you write few examples for this. That would be enough. Any doubts on this? Write down. Relationship between fundamental rights, relationship between fundamental rights, DPSP, and fundamental duties. Relationship between fundamental rights, DPSP, and fundamental duties. Fundamental duties. Write down. Article 51A G. Article 51A G. Article 51A Clause G provides a fundamental duty to protect and improve the natural environment, including forests, lakes, rivers, and wildlife. Forest, lakes, rivers, and wildlife. While Article 48, Article 48A provides while Article 48A provides that the state shall protect and improve the environment, and safeguard forest and wildlife. Safeguard forest and wildlife. And write down third. Article 21 has been expanded in relation to protection of the environment, such as such as right to adverse right to adverse right against adverse effects of climate change, right against adverse effects of climate change, rights against adverse effects of climate change. Ranjit Sinha case. Ranjit Sinha case. Ranjit Sinha case. Ranjit Sinha case, comma, MC Mehta case, MC Mehta case, MC Mehta case, among other. MC Mehta case, among other. Like you have right to clean environment, right to clean air, and all of this. So what happens is you draw this in your answer that this is the relationship that is established between fundamental rights and DPSP. The relationship is over sustainable development. 21, 48A, and 51A G. Right? 51A G. So you draw it like this within the UPSC examination. Sustainable development, Article 21 in relation to fundamental rights, 48A in relation to DPSP, and 51AG in relation to fundamental duties. Fundamental duties. Fundamental duties. Fundamental duties. So I'll explain to you first, and I'll make you write the relevant case laws. What the Supreme Court has ended up saying is that if you want to implement 51AG, which is the duty of a citizen to protect the environment, and 48A, which is the duty of the state to protect the environment, you can compromise with fundamental rights. Like we've already said, 39B and C, in relation to 14 and 19, if you want to implement 48A, 51AG for the protection of the environment, you can compromise with fundamental rights, and it would not be a problem. So our freedom of movement can be compromised for the protection of the environment. Our freedom to reside and settle can be compromised for the freedom of the or protection of the environment. Freedom of religion can be compromised for the protection of the. So there was a recent case in Rajasthan where you had these, forgetting the name, where you have certain trees which are sacred to the local community. No, there's a particular name that is given to this. It was in news last year. Sacred groves. It's important from environment perspective. So what had happened is that these maps. Right. So what has happened is that the Supreme Court gave a judgment that these sacred groves that are there for communities such as within Rajasthan, within Andhra Pradesh, within Telangana, whereby you have certain trees and certain groups of trees which are very sacred to the local community. They have to be protected. It is a fundamental duty of the citizens and of the state to protect them, not just in relation to protection of the environment, but also as a religious relevance. You get this conceptually? Education in the sense? In education also you can make that relationship, would not be a problem. You can actually make it in multiple aspects. This is one of those that are making you right because UPSC has a very good relationship with environment. So if they're going to ask the relationship, they're going to ask on the basis of environment. But you can also have this on other aspects. Let's say you talk about security. So in terms of security also, you have DPSP also that talks about protecting sovereignty integrity. You also have fundamental rights also, where one of the reasonable restrictions is security of the state, sovereignty integrity of India. You also have a fundamental duty, whereby it is our duty to ensure sovereignty, integrity, and unity of the country. You can also link it to the preamble also, because the preamble also talks about unity and integrity of the nation. Linkages you can make a lot among all of these four aspects. This would not be difficult. You get conceptually the linkage with sustainable development. Just write down the few case laws. Write down the Supreme Court In the Mirzapur case 2005, the Supreme Court in the Mirzapur case 2005 has said that any law any law or provision any law or provision can be tested for validity in relation to 48A and 51AG. In relation to 48A and 51AG. 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 Such provisions would be seen in harmony. Such provisions would be seen in harmony. If they seek to implement 48A and 51AG. 48A and 51AG. 51AG. Would be seen in harmony if they seek to implement 48A and 51AG. 51AG. Right on. Similarly, in the Arjun Gopal case, the Supreme Court has stated, the Supreme Court has stated that the duty to ensure a healthy environment, falls both on the state, in brackets 48A, falls both on the state and on citizens. Falls both on the state, in brackets 48A, and on the citizens, in brackets 51AG. And in brackets 51AG. 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 Right on. The Supreme Court in several judgments, has provided that essential features of sustainable development and environmental law would be seen in relation to Article 21, 48A and 51AG. 21, 48A and 51AG. And 51AG. 51AG. So this is the relationship between all the three in relation to sustainable development. This part is clear? Just write down one more separate part and we'll be done with this particular topic. Write down. The Supreme Court, separately. The Supreme Court in the Javed case 2003, in Javed, Javed, Javed case 2003, has said that the fundamental rights have to be read. Fundamental rights have to be read with fundamental duties and DPSP. Further, in the Ram Leela Maidan case, RAM Leela, Ram Leela Maidan, MAIDAN, Ram Leela Maidan case 2012. fundamental rights, fundamental rights and duties, fundamental rights and duties, fundamental rights and duties need to be seen in a balance, 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 need to be seen in a balance. Duties are correlative with rights, or rights are correlative with duties. Rights are correlative with duties. Rights are correlative with duties. So correlative with duties. Correlative with duties. Okay. So this is the relationship between all the three. Any doubts on this? If you want to make a relationship between any four aspects, any three aspects, let's say you take fundamental rights, DPSP, fundamental duties, preamble. One of the ways you can make a relationship between them is unity and integrity of India, because all four talk about this. So you have to find the common thread that links all of them together, and you should be able to answer accordingly. It would not be a problem. You can also make in relation to religious harmony. Like when you're talking about answers in society and social justice, you can make the argument that we have freedom of religion on principal distance model. DPSP talks about having religious harmony. So does fundamental duties. So you can make the linkages between all the three, and you can also bring in preamble. Preamble also talks about that we're a secular country, plus we have liberty of thought and worship and faith. This part is clear, right? So it's up to you where to make that kind of interlinkage. Sustainable development is a likely question that may come up in the future. Any doubts? No doubts? All right, so what we'll do is we'll take a break, and then we'll meet in a different, hopefully a different class altogether. It's 5:05, so we'll meet at 5:20. 5:20 we'll meet.